Hi, I'm Ron Fisk, and I live on the river. I'm also a fisherman and enjoy fishing on the Rogue River. My real problem is, where is this magic line? So the vegetation grows up 100 foot, like in 97, and then down 5 foot from the river. We don't have a real line to stipulate here. I think we've had very little problems, if you look at it as a percentage factor, between the fishermen and the owners of property. We all get along pretty well. I have fishermen on my property all the time. And for the most part, I do pick up trash that they leave there, but things get along. Is the state going to come in and clean up their portion of the property now, if they own that property? And there's quite a few problems that are arising, and that I think we're putting a lot of money into something that we don't have much of a problem with. We're creating more problems than we are fixing the problems. And of course, the government has a tendency of doing this kind of thing, get over involved, but I think if we leave things well enough alone, we'll get along together and put the money into education rather than putting it into
not the present flow of the river. As previously stated, the river is ever-changing and evolving over time with different pathways. Many of us have purchased properties with legal descriptions to specify center line of the river. We have watched the river locate further away or come closer to our current dwellings. The greatest issue here, found navigable, is where does each property boundary lie? Who decides on the new legal descriptions for each property? Who pays for the new legal descriptions? Is our county now liable for taxation refunds created by these new legal descriptions when property owners request reimbursement for erroneously paid taxes? What pending liability do the title insurance companies have that have insured title where the historic channel no longer flows and have not included exceptions to riparian rights? What liability does the real estate community have for misrepresentation of ownership size? And lastly, can an existing sales contract be invalidated due to a change in the size of the parcel? I hereby urge you, the landlord, to consider the consequences of your navigability decision for fairness and accuracy. As most of us who live in Jackson County already know, we all have the right to use the road to the high water mark. It seems to me the state already has a prescriptive easement claim for the public use of the river for recreation. Why wouldn't a prescriptive flow easement accomplish all the navigability study findings and stop this unnecessary legal burden on private property owners and our county? I disapprove of the implementation of this study.
On the microphone on the left is Pamela Hackett, and following verbal reading on the microphone on the right will be Ryan Lamb.
Do you mind if I speak on the right side? I like to be on the right side of the issue.
Mr. Lanning wants to come over to the other side. That's fine.
Good morning. My name is Pamela Hackett of Grants Pass. We have been stewards of the river for over 18 years. And thank you for the opportunity to address the board. I find it very painful to hear the theft of our property is inevitable. Not do we have to contend with the state lusting after our property, but now we understand the federal is also going to lust. For the following, what is happening here today before all to witness is an injustice that strikes at the soul of one of the foundations our freedom-loving country was founded on, private property rights. For the following summarized reasons, the study fails to meet the federal test and fails to provide evidence sufficiently that the board could come to the determination of navigability on the river segment under scrutiny. The division concludes the evidence presented favors navigability, and I assert the division needs to be investigated for special interest, infiltration, and corruption becoming its duty to the people. If we are wrong about this, the study does nothing to avoid this appearance. Rather, it invites suspicion. Federal law and court rulings may establish the legal test for state ownership, but only the judiciary may dispose of the title, not the division or the board. Even if the study is adopted, it will not prove or be judgment of title. The answer to both questions the board determined and asked is no. No, the study does not present factual evidence to meet the test for title navigability, and no, the board should not make a declaration of public ownership of the segment 150 years after the fact. The board to do so would be, as far as the evidence is presented, a lie, an unlawful taking that will cause an unknowable harm. This administrative proceeding does another disservice to the people by requiring them to bring forth evidence exposing their arguments to premature scrutiny, which allows time for the unscrupulous to fabricate, connive, and scheme evasions not known to us. The evidence presented by the board indicates not even the appearance of a meaningful procedure was intended. This board will force another unlawful taking by its adoption of a study and conclusion reeking of openly organized corruption and domination over the people. The board is encouraged to apply either of the proposed alternative solutions found here or return the matter to the legislator or the people, as the law already provides.
Applicable or riparian on February 14, 1859. I went about studying what the conditions were in 1859. The 1860 census showed a population, a white population, this is before the 14th Amendment, of course, of a little over 52,000 white people. The Rogue River Indian, the collective Rogue River Indian tribes were estimated to be about 9,500. By the way, ma'am, canoes can't paddle upriver. You can make all the claims you want about that. It just doesn't happen. So, you know, I'm really asking here, have you really done your job? Can we really trust this? Or have you already made up your mind and now you're coming back with the criteria or the reason? You simply have inserted the word could. Once you inserted the word could, you've opened the door for anything to have happened, from the sublime to the ridiculous. Aliens could have come down and taught Indians how to make hovercraft. Yeah, that could have happened. But we don't know. We don't know because we can't prove a negative. So, you know, you have a situation here where you started out saying one thing, and now you're saying something completely different. I don't think that we can really trust that the state government is going to follow through in the way in which they originally told us that they were going to approach this problem. I urge you to simply dump this